Anna Tibbetts, and as the president of Praxis, I have the pleasure of introducing our last speaker for the semester, Timothy Sandefur. Currently, Mr. Sandefur is a principal attorney at the Pacific Legal Foundation, where he leads the foundation's Economic Liberty Project. Also, he is an adjunct scholar for the Cato Institute, and in the past, Mr. Sandefur has won important legal victories for economic freedom, and he has filed briefs on a variety of eminent domain cases, including Kelo v. New London. He's the author of 3 books, the most recent entitled The Conscience of the Constitution, and he has written articles on a variety of topics which have been published in the Harvard Journal of Law and Public Policy, the NYU Journal of Law and Liberty, the National Review, the Washington Times, and several other places. Mr. Sandefur frequently appears on radio and TV programs, one example being Stossel. He's a graduate of Chapman University School of Law and of Hillsdale College. Please join me in welcoming our guest today, Mr. Sandefur.
Thank you very much. It's weird to be back. I graduated in 1998, and so seeing how the campus has changed and how spoiled you all are compared to the way we had it, man, that student union. We had a television set. Yeah, we really did. We had a television set next to the snack bar. That was the student union when I was a student here. I want to talk to you a little bit about a case that we recently litigated in Kentucky. My client, Raleigh Bruner, is a graduate of the University of Kentucky with an MBA. He decided that he wanted to start a business. He's a basketball player, actually, for the university, and decided he wasn't going to be making a living doing that, so he better get some business education going. So he got his MBA, and he decided that he would start a company. He started a moving business. And so he founded a company in Lexington called Wildcat Moving, named after the basketball team. And he hired a bunch of college students at the university, some guys to help load trucks and drive them around. And he had maybe 30 employees and maybe half a dozen trucks, which is really big for a moving company, actually. When it turned out, he got notified by the state that he didn't have a certificate of public convenience and necessity to run a moving company. Well, it turns out that in Kentucky, in order to run a moving company, you have to have a certificate of public convenience and necessity. And to get a certificate of public convenience and necessity, you first have to get permission from all of the state's existing moving companies. That's right. You have, in order to run a business, you have to get permission from your own competitors to start your company. And as ridiculous as that may sound, that is the law in most states and major metropolitan areas in this country. Certificate of Public Convenience and Necessity laws apply to a wide variety of industries, everything from moving companies, taxis, and limousines, to ambulance companies, and even hospitals. If you want to start a hospital, you first have to get permission from the existing hospitals. So, we filed a lawsuit at Pacific Legal Foundation. We filed a lawsuit arguing that this law is unconstitutional under the 14th Amendment. Now, I'm sure you all have your constitutions with you, so if you'll take those out, you'll... Now see, that joke works in any audience but this one. I'm sure you all have yours issued by the school when you show up, I'm sure. I always carry my handy Constitution iPhone app. Very helpful when you're in court. It got updated the other day, and I don't know why. I'll even put Obamacare in there. Anyway, the 14th Amendment says that no state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States, or deprive you of life, liberty, or property without due process of law, or deprive any person within the state's jurisdiction of the equal protection of the laws. So we filed a lawsuit arguing that this law violated all 3 of those provisions. Now, I don't have time to talk about equal protection, because that's a very complicated subject and there's just not enough time. So just talk about the other 2. The privileges or immunities of citizens of the United States. What does privileges or immunities mean? Well, interestingly enough, if you look back at the history, it turns out that there's actually a very rich common law history about what this term refers to. It basically means the rights that people enjoyed under the common law of England, or your natural rights that you enjoy under the law of nature. Blackstone, the famous English writer of the 1760s, refers to the rights of Englishmen as the privileges or immunities of Englishmen. And it turns out that one of the rights that the English Constitution respected was the right to earn a living without unreasonable interference from the government. This goes back to the greatest lawyer of all time, Sir Edward Cooke. Anybody here heard of Lord Cooke? Should have heard. Good, excellent. It's a shame that a lot of people have never heard of Lord Cooke, who was really one of the pre-founding fathers of America. He was Queen Elizabeth's Attorney General. He was Chief Justice of England before he was fired by King James for his opposition to the Stuart monarchy. There's a famous story that at a cabinet meeting, Lord Cooke and the various other members were sitting around the table with King James, and James asserted, "The king protecteth the common law." And Lord Cooke said, "No, the common law protecteth the king." And the king shouted, "A traitorous speech! For if the judges may make of the laws what they please, they will soon make of them shipmen's hose." Shipmen's hose are the stockings that sailors wear. What the king was saying was that if the judges can interpret the laws will develop runs in them like old stockings. Well, of course, Lord Cooke begged the king's forgiveness, but after a while the king had had enough of him and fired Lord Cooke from being Chief Justice of England, which is why the American Constitution forbids the president from firing judges. That confrontation between King James and Lord Cooke is sculpted on the front door of the United States Supreme Court building right now. Anyway, Lord Cooke, among other things, he stood for the right to economic liberty against the interferences by the Stuart monarchy. It turned out at the time there were things like, just to name an example, it was illegal for anybody in London, except for one guy, to make or sell playing cards. Queen Elizabeth had issued a patent, a monopoly, on the making and selling of playing cards in the city of London to this one guy. Now, why would the Queen do that?
Maybe so that she could control the number of decks so that she could limit gambling.
Yeah, that could be one reason. I had actually never thought of that, but that is a very good reason. The real reason was because the Queen was raising money by selling monopolies, right? The King of England can't tax without Parliament's permission, but he can sell things. And one of the things that the kings and queens of the time would sell was monopolies on trade. And so in the case of the playing cards, this guy made and sold playing cards without proper permission, and he was brought up on charges for it, and the case went up to the Court of Queen's Bench. And the court struck down the monopoly as a violation of the common law and said every British subject has the right to earn a living without unjust interference from the government. And Lord Cooke, when he became Chief Justice, issued a series of decisions following the same line. My favorite is the case of the upholsterers. It was a case where you couldn't practice upholstery without a license from the Upholstery Guild. And this guy went and he was upholstering without permission, and he was brought up on charges for this. He went up to the court. And what did the upholsterers say when Lord Cooke says, why do you have to get a license to be an upholsterer? What did the upholsterers say? Did they say, well, the reason for this law is to create an artificial scarcity in the upholstery business so that we can raise our prices and screw the consumer? No, of course not. They said what these people always say. It protects the public from bad upholstery, right? Oh, you wouldn't want to sit in that chair, right? So Lord Cooke said, in response to this, he said, "No skill there is in this, for a man might learn it in 6 hours." And then in one of my favorite lines from any court opinion ever, he said, "Unskillfulness is sufficient punishment." If you're bad at your job, that's punishment enough. There's no reason for the government to get involved. Customers won't buy products or services from you. And that's good enough. There's no reason for the government to interfere unless you're defrauding people or harming people in some way. But if you're just bad at your job, well, that's punishment enough. And he issued a series of cases like this. The case of the tailors of Ipswich. The case of the bricklayers and tilers. And when he, as I mentioned, after he got fired from being the Chief Justice of England, he was elected to Parliament. And while he was in Parliament, he wrote a series of legal textbooks, the Institutes of the Common Law of England. And in the Institutes, he writes over and over again about this right to economic liberty without unjust monopolies interfering with your economic freedom. And Cooke's Institutes were published in the late 17th century, and they became the textbook that young American law students would read to learn about the law in order to become practicing lawyers. And by law students, I'm referring, of course, to people like Thomas Jefferson, John Marshall, James Madison. Well, he didn't become a lawyer, but he read it. John Adams, and so forth. In fact, there's an amusing letter from a 16-year-old Thomas Jefferson saying, "Oh, I do wish the devil had old Cooke, because it's very hard to read. About half of it's in Latin, the other half is in that Elizabethan prose, you know." Anyway, so the Founding Fathers learned from Cooke this idea, the anti-monopoly Whig tradition. And they emphasized economic liberty and the right to be free from monopolies in the American Revolutionary period. Thomas Jefferson, in the Summary Review of the Rights of British America, published in 1774, among his other charges against the king, he complains that under British law it was illegal for the colonists to make things out of iron. You could mine for iron ore and make iron in the colonies, but you had to ship the iron back to England to be made into goods for sale for the retail market, which, of course, was, as Jefferson said, intended to support not men but machines in the island of Great Britain. That is, this law existed not to protect the public, but to protect politically established groups against having to compete fairly in the marketplace. James Madison, in an essay called Property in 1792, said, "That government is not a just government, under which arbitrary monopolies and exemptions restrict people's right to use their skills to earn a living in order to benefit others who simply have political influence to control society." And this right to economic liberty was referred to as the privileges or immunities of American citizens as early as the 1820s in a case called Corfield versus Coryell. Now, I said the 1820s, and you might be thinking, wait, the 14th Amendment was ratified in 1868. That's right, because there's already a privileges or immunities clause in the Constitution, right? In Article 4 of the Constitution, privileges and immunities of American citizens are protected when they travel across state lines. And Justice Bushrod Washington, George's nephew, was a Supreme Court justice. He wrote an opinion called Corfield, where he said, among the other privileges and immunities of citizenship is the right to earn a living without unreasonable interference. So, let's take a quick step past the Civil War. At the end of the Civil War, the 14th Amendment was ratified, and it includes a protection against state interference, because, of course, originally the Constitution primarily protected you against the federal government rather than the states. So the 14th Amendment was written and ratified by the Republicans who had gone through the Civil War, had seen the dangers of state tyranny, and at the end of the war wanted to prevent those kinds of interferences. And so they wrote an amendment to say, no state shall deprive you of your privileges or immunities either. And they referred during the ratification debates repeatedly to the right to economic liberty as being among the privileges and immunities that the Constitution would protect. That brings us to the very first U.S. Supreme Court case ever to interpret the 14th Amendment. And what was that? Does anybody know? Got my pre-law students in here? Called the Slaughterhouse Cases. In 1873, the Supreme Court reviewed a case from Louisiana in which the state of Louisiana passed a law that said if you're going to slaughter cattle in New Orleans Parish, you must do so at one privately owned butcher shop that just happened to be owned by members of the state legislature. Anybody in here from Louisiana? They usually go, yeah, things haven't changed much. So I always say, you have to imagine that, suppose that the state of Michigan passed a law saying every automobile in Detroit has to be repaired at Joe's Fix-It Shop on 6th Street or whatever, right? That's basically what Louisiana had done. New Orleans Parish was a huge center of the cattle industry. People would bring cattle down from the Great Plains or over from Texas to be slaughtered in New Orleans and shipped off to markets in the east. So prohibiting the private slaughtering of cattle was a huge deal. Put hundreds of butchers out of business overnight. And they filed a lawsuit that went up to the Supreme Court. And they argued, the Constitution says no state shall enforce a law that shall abridge the privileges or immunities of citizens. The privileges or immunities of citizens include the right to earn a living without unreasonable government interference in the form of arbitrary monopolies and exemptions. This law is an arbitrary monopoly or exemption. It doesn't protect public health. It doesn't impose any public health standards or anything. All it says is if you're going to slaughter cattle, you have to do it at the Crescent City Livestock Landing and Slaughterhouse Corporation. And they lost. The Supreme Court ruled against them. The Supreme Court said that the protection of civil rights had not been transferred to the federal government for protection, and therefore, although there was a right to earn a living, that right resided with the states for protection. It was up to state governments to protect that right. Instead, the privileges or immunities of American citizens were limited to a very short list of rights, such as the right to travel on the high seas. Right. Because that's what the Republicans were concerned with in 1868. The right to, see, all these former slaves were getting on boats to go on their cruise to the Caribbean for a week-long cruise to St. Lucia, and the Arkansas Navy was stopping them on the way. That's ridiculous. Of course it wasn't the right to travel on the high seas. The Slaughterhouse Court made no reference to any of the debates about the ratification or anything like that. They just said, we can't believe that the federal government would be in charge of protecting civil rights, therefore that can't be the law. Completely wrong. Unfortunately, the Slaughterhouse decision remains valid law today. The Supreme Court has never overruled that, and since 1873, it has never enforced the Privileges or Immunities Clause of the Constitution, with a couple of very minor exceptions. So if you had taken out your constitutions, you can take out a pen now and scratch a line through that clause of the Constitution, because it basically has been rendered null and void. One of our missions at the Pacific Legal Foundation is to get the Slaughterhouse decision overruled. And so we argued that this law in Kentucky violated that clause, knowing that the trial court judge would be obligated to dismiss that part of the case. So we move on to the Due Process Clause. The Constitution prohibits the government from depriving you of liberty without due process of law. What does that mean? What does due process of law mean? Now, this subject is often confused by the fact that people tend to leave out the most important part of the clause. They often call it the Due Process Clause, when the important part of the clause is of law. Due process of law. You are entitled not to due process of reading the Zodiac, or due process of a coin toss. You are entitled to due process of law before the government takes away your liberty. That means that the government, when it takes away your liberty, must do so according to a law. So, what is law? All the philosophy majors are going, uh-oh. Right under the desk, right? Obviously, that's a very complicated question. What is law is something that's been debated by philosophers and thinkers for many years. But we do know certain general answers to that question. A law is the opposite of an arbitrary act. A law is a principle. It's a rule that is applied always in like cases, right? It's a general, rational, public principle that guides how the state uses its coercive power. We can say these general principles about law, knowing that the opposite of law is just when the government says, "'cause I say so." There's actually a Latin phrase for "'cause I say so," ipsi dixit, because lawyers always sound real smart when they say things in Latin instead. So, ipsi dixit is an arbitrary act. "'Cause I've got the guns, therefore do what I say." That's the opposite of law, right? That's an arbitrary act. And it turns out that the phrase due process of law has roots in the Magna Carta. Magna Carta refers to the law of the land. It says no freeman shall be deprived of his property or liberty except by the law of the land, right? By some general principle, not just because the ruler says so. Now, suppose Congress were to pass a law, let's say that says you're required to clean up your front yard every Sunday morning. They'd probably do it under the Commerce Clause. And let's suppose that the president vetoed it. Obviously, it's not this president. He would probably sign that. But suppose that the president vetoed this law. And Sunday morning comes along, and there's a knock at your door. And it's the sheriff, and he says, why aren't you out in front? Why aren't you cleaning up your yard? You'd say, well, I'm not required to clean up my yard. He'd say, yes, you are. The Congress passed a law. You would say, no, they didn't. The president vetoed it. And if the president vetoed it, then it didn't become a law. And if it's not a law, then for you to arrest me under it would be for you to deprive me of liberty without due process of law, right? Now that's where there's been some procedural breakdown in how a law becomes a law, so that it doesn't become a law, so that you would be deprived of law, due process of law, if you get arrested under it. Now suppose that instead there's a substantive problem with the law. Suppose Congress passed a law that said the national religion is Scientology. Any Scientologists in here? Very surprising. Right, so suppose that they say that the national religion is now Scientology, and everybody's required to go to the Scientology church every, Sunday? Right? And the president signs it. And now Sunday comes along, knock at your door. It's the sheriff. He says, why aren't you in church? You say, I'm not a Scientologist. You'd say, yes, you are. Congress passed a law. You'd say, no, they didn't. They may have passed something. You can call what they passed a decree or a bill or something, but you can't call it a law because the First Amendment says Congress shall make no law respecting an establishment of religion. So whatever this thing is that Congress passed, it can't be a law. Congress cannot make law on that subject. And therefore, for you to arrest me under it would be for you to deprive me of liberty without due process of law. So unauthorized actions by the government also violate due process of law. That's the concept known as substantive due process as opposed to procedural due process. Actually, they're the same thing. Due process means that the government operates according to certain generally fair principles. Procedural and substantive due process are really the same thing. Now, that's where the government has acted in a way that violates an explicit constitutional restriction. Are there also implicit restrictions on what the government can do? The Founding Fathers thought so. The Founding Fathers, they thought of government as something like a bank guard, right? Let's say you own a bank, and so you're afraid somebody's going to come and rob your bank, so you hire a guard, and the guard stands in the bank, and he's got his badge, and he's got his gun, and now your problem solved, right? Not quite, right? You still have one little problem. You now have a person in your bank with a gun, and he could very well take out the gun and rob the bank himself, right? In fact, turns out there's a case where this really happened, in Florida, of course, where the bank hired this detective agency to provide them with a guard, and the guard conspired with others to rob the bank. Now, suppose that happened, and the bank fires the guard for this, and the guard shows up the next day and says, wait a minute, you didn't say that I couldn't rob the bank, it's not in the employment contract here. You would say, well, duh. The whole reason for hiring you was so that my bank wouldn't get robbed. I don't have to spell out in the contract that you're not allowed to rob my bank. That was pretty obvious, right? Certain implicit principles in the hiring contract. And in the same way, the Constitution contains implicit principles, things that the government can't do because that's obvious, or because natural law would prohibit it. If the government takes out its own gun and robs the bank to benefit itself, it's violating the principles of lawfulness embedded in the due process requirement. Okay? I used the term ipse dixit before. If the government pulls out its gun and says, do this thing because I say so, because it enriches me, because I want it, because I like it, that's why, because I don't like you, or whatever, that would be a violation of your right to due process of law. Now suppose that the government passed a law, I talked about these other examples about the yard and all that. Suppose government passed a law that said, people named Tim are stupid and dumb and we don't like them, so they're not allowed to be lawyers. Right? Now it's a general principle, because everybody named Tim is not allowed to be a lawyer, but it would still violate the due process of law requirement because it would be arbitrary. There's no reason behind it. It doesn't benefit the general public. It's a pure act of political will. Law is to arbitrariness as reason is to mere will. Right? So, suppose the government passes a law saying, we're going to take money from people who we don't like and give it to people who we do like. Would that be lawful? I know what you're thinking. That's all the government does. In 1874, there was a Supreme Court case called Loan Association versus Topeka, which is a fascinating case. In that case, the Supreme Court considered whether the government could take taxpayer money and use it to buy bonds in a privately owned railroad. These taxpayers, filed a lawsuit saying, this isn't a law, this doesn't benefit the general public, this simply benefits the owners of the railroad and enriches them at our expense. It's an exercise of mere political will by those who have the kind of influence that we don't have. And that's all it is. That's not for the public, that's redistributing wealth to benefit the politically successful. And the Supreme Court agreed. It said, a law to take property from A and give it to B is no less a robbery simply because it is done under the form of law and called legislation. This is not a law, it is a decree under legislative forms. And of course, if it's not a law, then that means it violates your right to due process of law. It takes away your property without due process of law. And then, of course, there's a very famous case that you've probably all heard of, Lochner versus New York in 1905. Anybody here heard of Lochner? Right? Whenever you say Lochner, you're supposed to go, boo! Lochner's so bad! Lochner's the worst decision the Supreme Court ever decided, except for Sir Dred Scott, right? If any of you have Justice Markman's class, oh, Lochner's terrible, terrible. I love Lochner. I think it was rightly decided. In fact, my license plate is the case citation for Lochner. 198 U.S. 45. It actually fit. Most Supreme Court cases wouldn't. What happened in the Lochner case was the state of New York passed a law saying bakers are not allowed to work more than 10 hours a day. Now, I think it can be fairly said that nobody in this room would want to be a baker in New York City in 1905. It's horrible work. It's really, really unpleasant. These little bakeries in the basements of buildings, these people would often sleep on couches next to these sweltering hot ovens so that they could keep the ovens going 24 hours a day. Just awful work. So, why would a person want to work more than 10 hours a day in a bakery? Why would Amon Schmitter, a German immigrant, go to his boss, Joseph Lochner, of the Lochner Bakery Company in Utica, New York, and say, I'd like to work more than 10 hours a day? Why would he do that?
He wants the money for...
Oh, no, of course not. It's because he's being exploited by evil capitalists, right? Of course, it's because he, as a friend of mine says, the reason that the baker wanted to work overtime is because he needed the dough. He needed the money, right? So he worked, so he goes to his boss and says, I'd like to work more than 10 hours a day. Joseph Lochner says, I'd like to pay you to work more than 10 hours a day. And they shake hands, and there you've got, that's it, right? Two grown adults who have the right to do with their own bodies what they please, and it ain't nobody else's business if they do. But the state of New York had made it illegal. So it went up to the Supreme Court on whether this was legal or not, and the Supreme Court struck down the law and said, these people have the right to decide for themselves what sort of employment contracts to have. It doesn't endanger the public. There's no evidence that working overtime in bakeries is bad, makes bad bread, or that it's bad for the baker. The health effects seem to be negligible. There's no problem with this. It's just that some people want to interfere with other people's right to earn a living, and that's unconstitutional. That's the Lochner decision. That's why I love that case. It's a case that stands for the proposition that you have the right to earn a living without unreasonable government interference. So how did we get to our present situation? How did we go from a place where you had the right to earn a living without government interference like that, to a situation where the government basically dictates to you what kind of jobs you can have, what you can earn, how long you can work, what your offices can look like, basically the entire content of your employment contract? The answer is the progressive movement. The progressive movement began in about the 1880s, and it more or less continues to the present day. And it consisted of four big ideas. The progressives had four big ideas. The first was, rights are just permissions. All that stuff in the Declaration of Independence about rights being, belonging to you by nature, just because you're a human being, no. Rights are permissions that the government gives to you for the government's own purposes. So, for example, Justice Oliver Wendell Holmes, the vilest human being ever to sit on the Supreme Court of the United States, a disgusting moral monster who truly believed there was no such thing as justice, there was only violence and rationalization of violence. Justice Holmes wrote a famous decision called Abrams versus United States. And you will often hear people say, in fact there was a book published last year saying, that modern free speech jurisprudence originates in Holmes's Abrams decision. It's where the term marketplace of ideas comes from, right? Well, when you actually read Justice Holmes's decision in that case, one of the first lines in it is, persecution seems perfectly logical to me. He says, but we don't persecute people because it's good for society to have a debate. And so we allow people to debate. We give them the privilege to free speech. But then, of course, we can take it away from them when we decide that it's bad for society. And so he also wrote the famous decision, Shank versus United States, which said it was okay to throw people in jail for exercising free speech if it was like yelling fire in a crowded theater. Does anybody remember what Mr. Shank was doing in that case? He was passing out pamphlets protesting the draft. Because that's just like yelling fire in a crowded theater. But that's Holmes's view of individual rights. Rights are just privileges that the government gives to you for its own purposes. The second great progressive idea was government exists to make society nice. Obviously, that's not what the founders thought. Jefferson says, the sum of good government is one which shall restrain men from injuring one another, shall leave them otherwise free to regulate their own pursuits of industry and improvement, and shall not take from the mouth of labor the bread it has earned. But no, we progressives, what with our modern ways, we know that society has shown, and science, and blah, blah, blah. No, government exists to make society nice and pleasant to live in. And so the progressives came up with a wide variety of ways to make society nice, like eugenics, prohibition, segregation, zoning. Remember what the purpose of zoning was when it was first designed? It was to keep racial minorities out of white neighborhoods. Of course, we never do that today, right? Right, government control over the money supply. The use of eminent domain for redevelopment. These were all progressive ideas for how to make society more pleasant to live in, because that was how progressives thought that government ought to operate. The third great progressive idea was judicial restraint. I'm sorry to say a lot of my conservative friends have adopted this nonsense. The idea of judicial restraint is the idea that if the government deprives you of your rights, the courts should do nothing about it. They should stand back and say, fine with us, we're not going to be activists. Someday I'm going to make a poster. Great moments in judicial restraint. Plessy versus Ferguson. Right, the government decides to force segregation on people in train cars, and the court says, well, we're going to let the democratic way, we're not going to interfere. Kelo versus New London, the eminent domain case where the government says we're going to steal people's property and give it to private developers for them to use for their own private profit. And the Supreme Court says, none of our business, we're not going to be activists. Right? Buck versus Bell. Many of you have heard of Buck versus Bell? Yeah. Another great Oliver Wendell Holmes masterpiece, in which he said that the Constitution does not forbid the state from forcing women to undergo sterilization operations against their will. That case has never been overruled. Holmes said in that opinion, 3 generations of imbeciles are enough. Maybe it was 2 generations. I never remember how many generations of imbeciles he thought was enough. But Holmes said, quote, all my life I have sneered at the natural rights of man, end quote. And he really did. He said, if my fellow Americans want to go to hell, I will help them. That's my job. Now, I've read Federalist 78, that explains the role of the federal judiciary, and the phrase, go to hell, is not to be found in it. In fact, Federalist 78 explains that the role of the federal judiciary is to protect us against the legislature, but not for Holmes. For Holmes, the idea of protecting you against the legislature made no sense because, again to quote Holmes, to speak of having rights valid against the government was like shaking your fist at the sky when the sky gave you the power to shake your fist. One might point out that nevertheless you can shake your fist at the sky. As I argue in my new book, in fact, dogs had a better sense of morality than Holmes did. Justice Holmes famously said that even a dog knows the difference between being kicked and being tripped over. Well, that's very interesting because dogs don't have conventions. Adam Smith tells us that nobody has ever seen dogs trade bones for other bones. So we know that dogs don't have any kind of conventions or society. So on what basis would a dog distinguish between being kicked and being tripped over? Other than nature. And if a dog can tell the natural difference between being kicked and being tripped over, why can't we come up with some other similar natural foundation for principles of justice to govern society? Holmes never answered that question. Instead, he said that the reason people believe in justice is the same reason a dog will fight for its bone. One might point out that dogs have perfectly good reasons to fight for bones. Natural reasons. In fact, it is good for dogs to fight for bones because unlike human beings, they can't create wealth or trade. And so for a dog to fight for its bone is in fact consistent with its nature and good for the dog. But for human beings, things are very different. But all of these subtleties escaped our illustrious Justice Holmes. Anyway, so that was the third great progressive idea, judicial restraint. Courts should stand back and not bother with the government taking your rights away. And the fourth great progressive idea was the living Constitution. The Constitution doesn't mean the same thing today that it meant yesterday. It's not worth the paper it's printed on, because we'll just come up with some new meaning tomorrow. Justice Brandeis, who was only slightly better than Holmes, Justice Brandeis put all of these progressive ideas together in a single sentence when he said, property and other rights of the individual must be remolded from time to time to meet the changing needs of society. Don't you love that word, remolded? What a great euphemism for violated, right? The government's not violating your rights, it's just remolding your rights. The government's not violating your rights when it steals your house to give it to a private developer to build a Costco. No, it's just remolding your rights. When the cop pulls you over and beats you up with a baton, he cracks your skull open, he's not violating it, he's just remolding your skull, or your rights. If it can be remolded, it's not a right. If it can be remolded to meet society's interests, it's only a permission, it's only a privilege. You all, of all people, you people, know the difference between a right and a privilege. You have only recently, and many of you still not, emerged from the realm of privilege into the realm of rights. I'm 38 years old. I've been out of Hillsdale for about 15 years. I love being free. I love my freedom. I love my freedom more than anything in the world. I love it more than my wife. I love it more than my home. I love it more than anything in the world. In any event, so the idea of recasting that freedom as a privilege and saying that it's a permission that the government gives to me is simply not true, and of course is a dangerous and disgusting concept. But those were the progressive ideas. Now, they were mostly in dissenting opinions until 1934 in a Supreme Court case that radically changed how the Constitution operates in the United States. That was a case called Nevio versus New York. In Nevio, I love talking about Nevio because it's such a stupid case. So, in Nevio, it's 1934, right? It's the depths of the Great Depression. Unemployment is what, 25%? And let's say you're running the government of New York, and let's say you're an idiot. But I repeat myself. You look out your window and you see these bread lines, right? And this terrible unemployment, hunger, people are needy. The solution to this problem is obvious, right? We can fix this problem if only we have the political will. Yes, we can! The solution is make food more expensive. Right? So that's what they did. They passed a law saying it was illegal to sell milk for less than 8 cents a quart in New York City. It was illegal to sell cheap milk to mothers to feed to their babies in the depths of the Great Depression. And Leo Nevio, a Rochester grocery store owner, filed a lawsuit saying, it's my milk. I have the right to do with it what I want to. It ain't nobody else's business if I do. And the Supreme Court said no. It said if the government wants to make that illegal, it can do virtually anything it wants to when it comes to economics. And that is the realm that we live in today. If you remember nothing else of what I say, this is it. The Nevio case was the crystallization of the progressive alteration of the Constitution that still prevails today. And it came through what the Nevio court called the rational basis test. The rational basis test is the test that judges use when determining whether a law violates the Constitution when it comes to economics. Other kinds of rights they're more skeptical, they're more protective of. Free speech, things like that, they care more about that, judges do. But when it comes to economics and private property rights, the court uses the rational basis test. Now the things you need to know about rational basis, it doesn't need to be rational, and it doesn't need to be the basis. It's really true. The rational basis test says if the judge thinks that a legislator might have thought that the law would be some kind of a good idea, it's constitutional. That's the test that courts apply to determine whether a restriction on your economic freedom is constitutional or not. Now the problems with rational basis are obvious, right? For one thing, it presumes that the law is constitutional and requires you to prove that it's not. In order to win a case under this rational basis test, you have to prove that this restriction on your private property rights or your economic freedom lacks any potential rationale at all. You have to disprove every conceivable basis for the law. Now you're thinking, wait, you can't prove a negative. That's right, you can't. Let alone an infinite series of potential negatives. Imagine that this was the rule for criminal law. Imagine that you were arrested for murder, you go to trial, you have an alibi, and at the end of the trial, the judge says, well, okay, but I can think of a way you might have done it, therefore guilty, right? That really is what the law is for economic freedom. So, we had a case a couple years ago called Merrifield, and this is a great case. My client, Alan Merrifield, he ran a pest control business. He didn't use pesticides. He didn't believe in pesticides. He only used structural devices. He didn't deal with insects. He kept squirrels and rats and birds away from buildings. And so he would do this by putting up screens, or those spikes that you see on buildings to keep birds from landing on them and stuff, right? Nixolite, it's called. Well, in California, if you want to put spikes on a building to keep pigeons away, you have to have a Branch 2 structural pest control operator's license. And to get a license, you have to have 2 years of training, learning how to use, store, and handle pesticides, and learning about the lifespan of insects, even though you don't deal with pesticides or insects. And you have to pass a 200-question multiple-choice examination on the use, storage, and handling of pesticides, a test that has no questions on it about pigeons or spikes. But, and then pass a criminal background check, etc., all the 2 years of training to get a license to put spikes on a building to keep pigeons away. And it gets better because the law only applies to pigeons. If you put the same spikes on the same building to keep seagulls away, you don't need any license at all. So we filed a lawsuit. We said this law doesn't make any sense. It fails the rational basis test, and it's therefore unconstitutional under the Due Process Clause of the 14th Amendment. And the state brought in their expert witness. And this guy was the guy who basically wrote the law. So it was a very interesting deposition, right? So I said to him, so under this law, you have to have 2 years of training to put spikes on a building to keep pigeons away. He said, yes, that's right. I said, but no training to put the same spikes on the same building to keep seagulls away. He said, yes, that's right. I said, would you call this irrational? He said, yes, I would. And the government's lawyer says, can we take a break? I always tell law students, the hardest part of a deposition like that is not going, I got you! You have to go, I see. Come back from the break, and he says, I'd like to clarify what I said about irrational. I'm thinking, I bet you would, right? He says, what I meant was, from the public's perspective, it might seem irrational, but what happened was this. Originally, you needed a license for all pest control work, and then people said, well, if you're not dealing with pesticides, you're not a threat to the public, so you shouldn't have to get a license. And those of us who already had licenses, we didn't want to face competition against people like your client. So we went to the government. We said, can you divide up the market so we can keep the pigeons, the rats, and the mice, because they're the most common pests, and those guys can have all the other ones. And I'm like, tell me more. So I went in front of the judge, and I said, Your Honor, it is an undisputed fact in this case that this law is positively irrational. And we still lost. Because that's the rational basis test. What the judge said was, I'm allowed to make up my own rationale for the law, and I can think that possibly you might need to know about pesticides even though you don't use them, because you might show up at a job site where pesticides have been used by others. Okay, but the law doesn't require you to have a license if you go to show up for a bat problem or a seagull problem at all, right? So we appealed that case to the Ninth Circuit, and I'm glad to say we won at the Ninth Circuit Court of Appeals. The court held that the government may not use its licensing laws simply to protect established businesses against fair economic competition from other people. Unfortunately, that's one of very few cases on the subject, and the 10th Circuit Court of Appeals, which governs Colorado, Oklahoma, and other states, has held just the opposite. That court has held, in a case called Powers, that the government can use licensing laws simply to prohibit fair competition, simply because it wants to. The Supreme Court has not taken up that case. So get back to my Kentucky case. I have to prove to this judge that this law is positively irrational and only exists to protect established businesses against legitimate competition. So we got all these documents from the government. It was really interesting. It turned out that in the 5 years before we filed the lawsuit, 39 people had applied for licenses to run moving companies in Kentucky. Of these, now here's how the statute worked. You apply for a license. First, you have to notify all the existing moving companies. And they're allowed to object. And when they object, and they often do, you have to go to a hearing. And at the hearing, you have to prove to the government that existing moving companies are inadequate. What does inadequate mean? That's right, nobody knows. It's not defined in the statute, regulation, or any case law in the history of Kentucky. And once you prove that, then the government will give you a license if it thinks that a new moving company would serve the present or future public convenience or necessity. Now, how, this is a question for the back row, how would the government determine what the future public convenience is? They can't, right? Exactly. They can't, right? I'm old enough to remember New Coke. The Coca-Cola Corporation has all the powers at its disposal to determine what consumers want. And even they didn't know that nobody wanted New Coke, right? You could change that to the Microsoft Zune, right? Microsoft thought the public wanted the Zune, They were wrong. How is a group of bureaucrats at the Kentucky Transportation Cabinet going to decide whether the public needs a new moving company? Well, it turns out in deposition, the government's or their lead witness testified that, quote, there are no objective criteria, end quote, for determining whether there needs to be a new moving company in the state of Kentucky. So, of the 19 people who had protests filed against them, all of them but 3 gave up. Why? Because it's a very expensive and time-consuming process to go through a hearing. You have to hire a lawyer. Law requires you can't represent yourself. And it often takes 6 months, a year, to even get a decision after your hearing. What entrepreneur can afford that? Right? So most of the time, people just give up. Or they instead apply for permission to buy a license from an existing company. And guess what? Nobody had ever protested against one of those. Why not? Because it doesn't increase competition, right? So the existing firms had no reason to protest against that. Only 3 companies actually tried to go through a hearing and prove that there needed to be a new moving company. One of them even hired an expert witness economist to testify to market demand. Of course, the agency rejected that and said, there's not enough demand. Denied. In another case, Michael Ball had been in the moving business for 35 years when he decided to get his own license and start his own company. He was denied a license in a written opinion that said, you're fully qualified, but we don't need any more competition in the moving business, therefore denied. Even though one of the companies that protested against him testified at the hearing that, quote, he would make a great mover, end quote. The third one was more interesting. She applied for a license, and she was denied for 2 reasons. First, because they didn't need more competition, and second, because she had operated without a license before applying, and therefore it operated illegally, and we don't like that sort of thing. Well, after she was denied a license, she filed a lawsuit alleging racial discrimination, because it turns out all the moving companies in Kentucky are run by white guys. So she filed a discrimination lawsuit. Within a couple months, they had settled that lawsuit. One of the conditions was that she would be allowed to buy a license from an existing company. That was granted in a written opinion that said, you've been in the moving business for a long time, and that's a really good thing. No reference to the fact that it had been illegal. So we gave all this evidence to the judge, and I'm glad to say in February of this year, the district court judge struck down the law as unconstitutional and said all it was a competitor's veto that prohibited free competition in the moving business. That is the first federal decision since the New Deal ever to strike down one of these laws as unconstitutional under the 14th Amendment. Now it's very gratifying, but it's really baby steps. Right? We at Pacific Legal Foundation, groups like the Institute for Justice, the Washington Legal Foundation, the Center for Individual Rights, the Goldwater Institute, these organizations across the country are trying to get the law to respect once again the right to earn a living, a right that goes back at least 500 years in the Anglo-American common law tradition, a right that even liberal Justice William Douglas called, quote, the most precious liberty that man possesses, end quote. Unfortunately, it's an uphill battle, but I hope that maybe there's some of you in the audience who might be interested in taking part in this battle. I mentioned that I graduated in '98. In '97, when I was a junior here, there was a CCA seminar on economic liberty and the Constitution. And my good friend Clint Bullock came to speak. At the time he was with the Institute for Justice. I had never heard of any of this law. I had never heard of any of these things, about these cases about taxi cabs and limousines and hair braiders and the Slaughterhouse Cases and Lochner and the right to earn a living. And by the time he was done with that speech, I thought, that's what I want to do with my life. And so I went to law school, and I graduated from law school with the sole purpose of representing entrepreneurs and fighting for economic liberty in the courts, and it's a very gratifying job. I wouldn't do law if I couldn't do this kind of law. Maybe some of you might be considering a career in law where you might advance principles of liberty that you believe in deeply. And if so, I hope you'll consider a career in public interest law, working for one of the many great organizations out there. Thank you very much for the invitation. I'm happy to answer any questions you might have in the minutes we have remaining. Sorry to go on for so long, but as I told Ms. Tibbetts, as a lawyer, I'm paid to talk by the hour, and I will fill whatever space is made available to me. Do we have any questions? Yes?
Does the Cooke Foundation provide any sort of scholarships for people to go to law school to do what you're doing?
Law school scholarships, I don't know, and I don't know whether there are any available, let alone whether Cooke makes them available. But there are many programs that are available, and there are certain types of fellowships. You can get the Humane Studies Fellowship, for example, available through IHS, would fund law students, for instance. Scholarships in law schools themselves, no, but there are many great programs for law students. The primary one that I emphasize always is the Institute for Justice's Law Student Seminar, which is held every year in DC, and they fly you out there to learn how to do public interest law, get propagandized to a little bit, and it's very educational and helpful for people who want to either do this at one of these institutions or do it on your own. You know, you can be a private practice attorney and do an occasional case on the side, representing an entrepreneur. And actually, there is a great deal of demand for that. We, being a nonprofit, we have to find the right cases and just do very few. And we have to do constitutional issues. And a lot of the time we get calls from small business owners who just need legal help of some sort, and we can't do that. There's a huge demand for that. And there are clinics at the University of San Diego and the University of Chicago that help small businesses just to get off the ground. Incredibly important work, and something that there are resources available to help with, definitely. Of course, clerkships, paid clerkships at Pacific Legal Foundation, Goldwater Institute, and other organizations can certainly help. And then schools often have public interest legal foundations that can help fund you the scholarship for any public interest legal work you might be interested in, whether it's on the libertarian side, conservative side, liberal side, whatever. And that helped me when I was in law school. That was how I was able to pay for my summer clerkship in Washington, D.C. Yes?
So there's a lot of freshmen in this class too. What would you tell us to do over the next few years if we're interested in law school? What can we do at Hillsdale to maximize that potentiality of going to law school?
Well, that's a great question. Freshmen, what can you do? Okay. First, I'll say the most important skill you can possibly have to do law is writing. Vastly, overwhelmingly, what you do as a lawyer is write. I often tell people the reason I'm a lawyer is because it's the only way I could find to make a living as a writer. and because I loved writing, but you know, I didn't want to live the bohemian life. So the public speaking is a large part of it, but it's a small fraction of it. And so writing, and especially writing in a non-technical way, conveying complicated ideas as simply as you can and as clearly and convincingly as you can is really important. So when I get resumes for applicants for law clerkships, first thing I look for, well, one of the first things I look for is whether they've worked on their student newspaper. Because the writing they teach you in law school is very specialized. I want to know that a person can write in a way that's persuasive, concise, and clear, and that's very helpful. As far as classes to take, I took Professor Markman's class. As you can probably tell from my talk, I stand pretty much on the opposite side of the intellectual spectrum from Justice Markman. But I found it very helpful. And I know you have your Constitution class. I don't know the curriculum for it, but I'm sure that's very helpful too. But I would focus more on learning how to put arguments together. You know, learning what kinds of arguments appeal to people, why, how to put those arguments clearly, simply, and efficiently in what you write. That's really the most important skill. Every law student is a political science major. Every one of them. So trying to distinguish yourself in your major, you know, isn't going to be as effective as just learning those skills. Now, as far as law school is concerned, people will say, what school should I go to? If you don't go to one of the top 10 law schools, if you get into one of the top 10 law schools, go, no matter what it costs. Doesn't matter what it costs. You'll make it when you graduate. So take whatever loans you need to, graduate with your Harvard degree, and there you go. But if you don't get one of the top 10 law schools, and there was no way in hell I was going to do a top 10 law school, then it doesn't really matter that much as long as you don't go to Cooley. As long as you go to a mid-range school, then all that really matters there is how good you are at your job, which of course is all that really should matter anyway, right? So I would put less emphasis in, unless you really think you're going to get one of the top 10, don't worry too much about what law school you go to, as long as it's a respectable school. And then we were talking actually beforehand that a piece of advice that I wish I had known is follow the professor. If you find a professor who's really great, follow the professor no matter what the subject. That's less good advice in law school because your program is mostly done for you. You have to take certain classes, but half of your classes you get to choose, basically. Find a professor who's great and follow that professor no matter what. I wish I had known that when I was a student here. I would have taken every class with Dr. Whalen that was available, no matter what the subject matter, because that person will teach you and get you inspired in the ideas. So, and then the other thing that I look for in resumes is whether you've demonstrated a commitment to the principles that we're interested in. That means Federalist Society, Institute for Humane Studies, Institute for Justice, Cato, Cato University. These sorts of extracurricular opportunities that are especially available for Hillsdale students. Take advantage of those. Ah, come on, there must be somebody got pissed off. Somebody's like, wait a minute, judicial restraint's a good thing, isn't it? Yes?
So you mentioned all sorts of like IJ and Pacific Legal and various institutions that are sort of fighting the fight that you're fighting. Is it like a hopeful, do you see hope in the future?
Very much so.
Okay.
I am very optimistic. And I get asked this question very frequently. Isn't everything going to hell? And to quote The Simpsons, short answer, no with a but, long answer, yes with an if. Well, I'm pessimistic in the short term, as I think was borne out yesterday by the president. But I'm very optimistic in the long term. I think the president and his intellectual allies are helping to generate ideas about what constitutional government would be like and generate real interest in regular Americans in seeing us return to a system closer to what our system is supposed to be as far as liberty and limited government, and particularly law students. I mentioned I graduated in '98, so I was in high school in the mid-'90s, and at the time, a lot of people had never even heard the word libertarian. I mean, it really was an uphill battle to be recognized and understood for what you were talking about. Nowadays, I give talks to the Republican women of Napa Valley, and they've all heard of the Kelo case. They know about the wheat case from the 1940s, in which the Supreme Court said that it can control how much wheat you grow, Wickard versus Filtner. Right? And people are getting more constitutionally literate, is my perception, and especially the younger generation. And the resources that are available for the coming generation of law students are amazing. Now, it's very slow. It's going to be a long process. Law, especially, very slow. There's an old saying, I think Niels Bohr said, old theories never die, just old theorists. You're never going to persuade Justice Scalia that judicial restraint is a bad idea. It's not going to happen. But he's going to be succeeded by another justice someday, and he'll be succeeded by another justice, and gradually we change the world in that way. There's a reason why the ties they sell at the Supreme Court gift shop have little turtles on them, because law is a very slow process. And so, taking that long view, I'm very optimistic. Look at how long it took the progressives. They started in the 1880s, and they only really prevailed in 1934 in the Nevio case. That's 50 years, and they had it easier than our side does, because they're helping the poor. Whereas we have to explain to people theories like public choice and regulatory capture and prices as an information mechanism and competition as discovery. These are ideas most people not only don't know, but they've been kind of programmed by the mainstream media to be skeptical of to begin with, and so it's an even more uphill battle for our side. But I think when I meet these law students that come in and say, I went to law school because I was so mad about the Kelo case. When you look at the average American and say to them, well, Obamacare is just a tax, actually. It's not a commerce thing. They laugh at that because they know that. Come on, right? So I think that we are generating a rising movement of people who are interested in constitutional government. It could go awry, of course. It's tragic to me to see how much of, for instance, the Tea Party movement has been taken over in large part by the secessionists and that kind of nonsense. I think that's a real shame. But I am still, in the main, optimistic that the rising generation is going to help restore us to the path of constitutional freedom, if we live long enough. In the long run, we're all dead. But as Walter Williams said, what do I care about future generations? What have they ever done for me?
We're actually out of time, but thank you for